Good afternoon, and today I want to talk about perjury. We all know that when we go into family court, it's perjury palace. That's even what opposing counsel told me one time is that Harris County courts are perjury palace. And perjury is against the law. Aggravated perjury is against the law. And we have to remember that we have three branches of government. We have the executive, we have the legislative branch, and we have the judicial branch. The legislative branch makes the laws, the judicial branch enforces those laws, police, judges, all that. They don't get to override the legislature. They don't get to say that they're not going to enforce a law that the legislature has already passed. It doesn't work that way. The DAs don't get to say we're not going to prosecute that. While the DAs do have prosecutorial discretion, that's another rabbit hole we can get into later. But let's put in Texas Penal Code perjury. So when you go to chapter 37 of the state statute page, you're going to see something like this. This is Penal Code Title 8, Offenses Against Public Administration, Chapter 37, Perjury and Other Falsifications. If we look at section 37.01 definitions, I want to go over what a court record is. So let me read it to you. Again, I'm not an attorney. I'm not giving you legal advice. I'm just telling you where to go look, where to read, where to comprehend, and where to put it together. So a court record, what is a court record? What is the definition of a court record? Some of y'all in family court need to know what a court record is. So let me define what a court record is. It means a decree. Do you have a divorce decree? A judgment from a judge? Do you have an order for possession and access? Subpoena, warrant, minutes, or other document issued by a court of this state, including the court reporter's transcribed transcription or the court's record. That's what we always say. Well, let me get the court's record. Let me call the court reporter and see if they can transcribe the court's record and give it to me for my appeals purposes. So you have to remember that that court transcriber, the court reporter, is also part of the government. They are storing these court records for the state. Also, the district clerk. Where do you e-file your cases? Into the district clerk's e-file, and then they keep that for the state of Texas for as a government record. Now, what's a government record? Let's scroll on down to number 2. Now, if we scroll down to number 2, government record means anything belonging to, received by, or kept by government for information, including a court record. Well, what's a court record? Let's scroll back up here, right? Anything belonging to, received by, or kept by government for information. The district clerk holds all of these government records for us. Anything required by law to be kept by others for information of the government. So the district clerk keeps our court records. Why? Because the district clerk has our decrees, it has our judgments and orders, it has a record of the subpoenas and the minutes of your court hearing, right? So if somebody's lying on the record, a judge can't just say, hey, look, we're just going to overlook this, right? And we're going to get into a little bit more. Let's just keep scrolling. So if you scroll down from 37.01, it says, what is a statement? What is an affidavit, right? A statement means any representation of fact. An affidavit is a statement of fact. An affidavit is filed with certain filings, petitions. And if those affidavits are wrong, those are statements of fact, right? So that the judge awards an ex parte TRO or an ex parte protective order. Those affidavits that are being e-filed onto the court's record becomes a government record when it is kept by the district clerk. So remember, an affidavit is a statement of fact. And again, here it's reiterated, statement means any representation of fact. And so that's where I think a lot of people when you challenge what perjury is or aggravated perjury, a lot of people don't understand that you need to challenge these affidavits, especially when you can prove that these affidavits have created a harm because they're based on misrepresentation of facts. We went over yesterday the Texas Lawyers Creed. We know that lawyers can't make statements of fact that they know are untrue. Also, misrepresentation. So let's go into perjury. Now, remember, attorneys have an oath on file. They do have an oath on file, which they have to uphold the state laws and the Constitution, just like the judge does. When we get into perjury, let's scroll down. Perjury was last touched in 1994. It was amended in 1993, and it went into effect September 1, 1994. So 30 years ago, more or less, this is the last time this statute has been touched at our legislature. So let's read into what perjury is. A person commits an offense if, with the intent to deceive and with knowledge of the statement's meaning, he makes a false statement under oath or swears to the truth of a false statement previously made, and the statement is required or authorized by law to be made under oath, right? He makes a false unsworn declaration. So when they ask you to provide an affidavit to be signed and sworn to by a Texas notary, and the law says that you need to provide a affidavit with that petition or with that motion or the ex parte protective order or restraining order. Remember, when the law says you need to have an affidavit included and you lie on that affidavit and they can prove it, that is what perjury is. Now, a lot of people get perjury mixed up with aggravated perjury. Remember, perjury is just a Class A misdemeanor. Aggravated perjury, because it's aggravated, is a felony to the third degree. Some of y'all that have seen some of my magistrate classes have seen that where does a felony go? A felony shall be forthwith before a magistrate of the county, as per the Code of Criminal Procedure. Shall be forthwith, which means it should immediately go before a judge who is a magistrate. And again, who are magistrates? District court judges. What are family court in Harris County? District court judges. So again, I'm just reading and putting two and two together, and this is what we're coming up with. Now, Section 37.03, aggravated perjury. What is aggravated perjury? We just went over perjury, but what makes it aggravated? A person commits an offense. If he commits perjury, you have to commit perjury first to get to aggravated perjury. If he commits perjury as defined 3702, and the false statement is made during or in connection with an official proceeding and is material. Now, material, what does material mean? Material means it's got to be material to the case. If you have a slightly different version of the time and on or about 5:30, that's not perjury, right? It has to be material to the case in which you're dealing with. So let's just say in my case, right? My ex said that I slapped my son or I beat him or I punched him and he had a bruise on his face. She wasn't in San Antonio, but she made a police report saying that I assaulted my child. She wasn't in the zip code. She wasn't in the city. She just went and flat out made a false report to law enforcement. Again, is that a government record? Is it kept? Where is it kept? Is it kept by that agency? Is it sworn to, right? All those elements you have to look into. But in this case, she filed it on an affidavit and she had several versions, and the judge allowed her to have several versions when I called it out and I said, hey, judge, she has just committed aggravated perjury because her affidavit that was sworn to for a temporary restraining order was filed into my case. She then had 4 variations of her affidavit in which we were talking about a facial bruise. So when I brought up aggravated perjury, again, that is a third-degree felony. It should be referred to law enforcement, and it shall be forthwith before a magistrate of the county. So let's keep going on. Again, this isn't legal advice. I'm just telling you what I've read, what I've put together. Inconsistent statements and information or indictment for perjury under section 37.02 or aggravated perjury under section 37.03 that alleges that the declarant has made statements under oath, both of which cannot be true, need not allege which statement is false. At the trial, the prosecution need not prove which statement is false. And again, this was last touched 1994. So again, you have false reports to peace officers, federal special investigators, law enforcement employees, correction officers. False reports regarding missing children or a missing person are all in here. I highly recommend that if you're in family court, you're having issues with perjury or aggravated perjury, that you come and you check out Texas Penal Code Chapter 37 and you start reading from there. Hey guys, tell me what you think. Again, I'm going to be putting more videos out like this to help at least point you in the right direction when it comes to perjury and other falsifications in your family court case. Thanks for watching.